been a law professor at University of Baltimore School of Law, teaching primarily intellectual property subjects. His special area of research and personal interest, I think, as well as obvious expertise, is in the design area. Before he was a law professor, he was a practicing patent attorney. And currently, he's working with the American Bar Association section on intellectual property law as the chair of their special committee on the Hague Agreement dealing with industrial designs. Day after tomorrow, I believe, he is scheduled to leave for Jakarta, Indonesia, where he will be doing some teaching of some law professors there in the area of industrial property, intellectual property, industrial design. As a consultant, Professor Fryer has been called upon on more than one occasion by the Congress and by the Register of Copyrights. Yeah, this is the good part now. To help us and the Congress with concerns about design protection. It's a large field and one that is not even on most of our screens, as you think of it that way, for us here in copyright. So it's with special pleasure that we welcome him and what he can do by way of orienting us to that field of law, that field of endeavor, what's going on out there. A few weeks ago, literally, I guess it's been a few months ago, Congress passed a law that had something to do with boat hull design protection, and it landed in our laps, and we just suddenly, my word, where did that come from? And are there more out there like that that we should be looking for in the future? I expect by the end of the hour, Professor Fryer will have given us a few clues on which way to look or to duck or to embrace as we see developments coming down the road. Professor Fryer, as the hour nears 3 o'clock, don't be offended if some people start leaving. They have carpools and other commitments.
Me too.
So we may escort you out. So
I have to be
again,
in Baltimore at 5:30 for a class.
quickly, Professor Fryer, we're glad you're here.
I spend a lot of time in this room. You know, I come here for my education every year when they do the ABA, and Maryland does.
Your photocopy.
Has been a good friend. On many occasions, educated me and many others about how the copyright system works. So it's really a pleasure. This is, frankly, I must say, and I don't mean this to just, you know, put it out for this meeting, but I think this is, you all are one of the finest government agencies, I think. I tell everybody that, and you've always been very professional in your work, and you know, I think, you know, everything indicates that, you know, that will be continuing. So it's a pleasure, and you seem to get more responsibilities because of that. You might wonder why things get here, you know, and maybe it's because you can do it. Well, it's a pleasure to talk about industrial designs. This is, I think, perhaps close to as passionate as much as I can have about intellectual property. How to go about this? In other words, how to give you an introduction. I've given certain rules or guidelines, I guess. First, don't talk law. Try to keep this very general. Keep it fun. And you know, when you walk away, you just kind of get an impression. You don't. You're not. I'm not trying to teach you anything. So, you know, you might take notes, but that would be not really that important. The second thing I said to myself is that you can't deal with this subject unless you do something visual, and you work with that all the time. You see everything a lot of things you examine and so forth. You're looking at the appearance. I mean, I can't possibly put it into words. There's just no way. So we have to communicate. It's very difficult to communicate on this subject, so I'm going to use as many visuals as I can. And I brought one prop, which we may use. So the first thing I'd like to do is get you involved. And the way to do that is, I think I want to ask you if, in your opinion, the appearance of a product makes a difference to you. So I'm going to ask for a show of hands. How many people, when you buy clothes, you're looking at the clothes, the appearance of the clothes makes a difference to you? Let's see. Okay, yeah, that's a fairly, so it's not just the way it, you know, pockets and things like that, but it's, you know, the way it looks. How about when you buy a car? Do you just look for how the car works, or is it important to you? Let's see, how many is important to you how the car looks to you? All right, so you're following down. How about when you buy furniture? And you go to the furniture store, you already got her hands. And you say, well, you know, I want a 3-person sofa, or I want a sofa with a bed that pulls out, and in effect, but also you want, you know, you want it to look all right. So how many actually seriously think about the way the product looks when you look at furniture? All right, well, I'm on a roll here. Then I guess I've made my point, that how a product looks does make a difference. And that is what industrial design is partially all about, how a product looks. It does, of course, make a difference how the product works, but you've got to be able to kind of think about those separately. The problem is, as many have said in the past, form follows function. That is, the way a product appears also has to, frankly, deal with how a product actually is functioning and how it needs to function. So if you don't do a little more analysis of that question about form and function, you begin to get confused, and that's perhaps where a lot of law is fairly kind of trying to develop that concept of, you know, just where the appearance of the product is and how it relates to the function of the product and so forth. Now that's probably as heavy as I'm going to get today. I mean, that's heavy stuff. I mean, that is probably where the real complexity of the law is in terms of protection, both in copyright and in other areas. Well, you know, I must make fun of lawyers from time to time. I am a lawyer, but this kind of relates me to this particular cartoon. You may not be able to read it, so I'll read it to you. So it says, "The honest lawyer."
Oh.
And there's a copyright attorney on the door. I don't know, it doesn't have to be a copyright attorney. It could be a patent attorney, a trademark attorney, any kind of attorney, probably. Copyright, particularly, imitation is the sincerest form of my income. So you get the message? I mean, how it looks makes a difference, right? And if somebody makes something that looks pretty good, pretty popular, I don't care whether it's furniture or a boat hull. See, we already got to that. Somebody's going to say, I'm going to copy that, and I'm going to ride on their reputation, and whether you categorize it, let's forget about the legal mumbo-jumbo. I mean, they're going to, you know, it's a natural thing to do. So there's got to be an attorney, more or less, to kind of guide the person to essentially, if possible, do this without getting into legal trouble. So that's you might say is the beginning of the story for this. So what I'd like to do now is, I'll leave this up for a little while, perhaps as a reminder of, you know, in many cases, you know, why we have a legal system. To implement the laws and to interpret the laws, and also to, you know, we have counselors and offices that provide the necessary legal process for all of this. Well, what I'm going to talk about today, that's just an introduction. What I'm going to talk about today with you is a little bit of the history of the protection of designs, and about the types of design protection and the development in the United States and in other countries of protection of the designs. Now, I don't mean to confuse you. When I use the word designs or industrial designs, at least in this particular program, I am not trying to be very technical. You know, it's just a short form for designs. But obviously, you have to be more precise in some context. And I'm going to try to use some visuals for this, so that feel for what's going on. Well, the first thing is, I guess I've got here a brochure. I don't know whether you know this. Maybe perhaps you know some friends that are industrial designers. People call themselves industrial designers. There's a group of people out there, and I didn't know much about them, frankly, until I got into this, who actually their career is based on doing industrial design work. So they have an organization called the Industrial Designers Society of America, and this is the brochure they put out, which is, you know, for a career, if you wanted a career in industrial design. And as far as I can tell, these people, the designers, are artists primarily. They absolutely have a visual talent. They have the ability to draw. They have the, you know, just all those skills, but they do it for commercial purposes in connection with products. And so I thought it would be, and they're very independent. They're just like artists. They're very independent. You know, they have their own, usually they're small firms. You know, a couple of them they get together. They're like Hollywood stars. Also, they have celebrities, and they have really premier designers, and they do exhibits, you know, of like clocks and so forth, of how they design them. So these, you have to kind of recognize the personality. They're very independent personalities. They don't always work too well in large companies. That's why they're inside, you know, they have their own firms. And many of them are world-renowned, and they're known throughout the world. And this organization is merely one of, this is the United States organization, the Industrial Designers Society of America, but they have organizations of the same type that essentially belong in an umbrella organization throughout the world. So there's organizations of designers throughout the world that are organized and meet, and for the most part they could care nothing about law. They don't care about protection. They're only interested in the aesthetic and the development of their particular creative work. So it's been a real shock for me to have the opportunity to actually meet these people and to try to explain sometimes that they have to be concerned with the law that affects what they create. For reasons that we say here, there's somebody that's going to imitate their product, and the product's not going to be worth much if essentially it can be imitated by anyone. And that's on a world level. So I took out of this brochure the definition of industrial design. And by the way, everything I've shown here is in your handout. So if you can't read it up here, you should be able to take a look at it. We'll put the lawyer to rest for a moment, and we will get back to the lawyer. So this is something I think it took me years to understand this, so I don't think it's very easy to try to absorb it. But you know, what is industrial design? And you can take a look at this, but I'm going to tell you a story that happened to me on my way from Disney World. And this may be a better explanation than anything I could do word-wise. It's kind of a long story, but Marilyn knows this fellow. Professor Sato has been going to the meetings in Geneva on the treaty, representing the Japanese. He's a professor at Chuyo University. And the Japanese study everything. I mean, they want to research what's going on around the world. So they asked him to do some research on industrial design, which happens to be one of his major interests. So I suggested he go down to Motorola. Motorola is a small company in the United States that makes a variety of things, cellular phones. I didn't realize how big they are because they have people all around the world. It really is one of the giants. Just to give you an idea, they file more design patent applications in the United States than any other U.S. company. So I suggested he go down there. I knew one of the people that worked in their intellectual property department. So we went down there. And our purpose was to see how the industrial design process works. So they took us into the department of the industrial designers, which was really attractive. You know, I mean, the furniture was really attractive, the coloring, and you just felt you were not in the same building The rest of these people were just working in kind of just straight office buildings that, you know, the square corners and everything. And so we sat down and we had a demonstration of how a product is made, how a cellular phone is made. It starts there, more or less, at least partially there. Somebody has to work out the technology that goes inside the phone, the package that the phone is in, and but the designer has to take all those parts, put them together, figure out how they will work, how somebody will actually use them, and then look at it to see how it will appear, what colors should be there, you know, the whole thing. Now, what was so exciting was that they actually do this all on computer. So they showed us this three-dimensional visual image of a phone that has been created in color. And they can change it so you can see the outlines and everything. So that's what an industrial designer does. That's what industrial design is. It's the integration of all those different functions, that human functions that, you know, and they go through, they showed us a testing room, and they take you in the testing room, and they give you this phone that they had worked out, and they say, now, how do you like it? Try to do some numbers on it, see how it works, see, you know, put it to your ear, is it all this coming, is there any reaction you have? And they go through this time after time and make changes in the product. So these people are concerned with not only the functional part of the product, but also how the product looks. Do you like it? Is it attractive to you? And frankly, you know, there's a lot of varieties. I don't know whether you've seen the Motorola. Does anybody have a Motorola phone? Cellular phone? They're mainly commercial users, I think, you know, corporations. They're a little more expensive, so I wouldn't probably buy it, perhaps. But it has more functions in it. They also make pagers. It has this big circular disc-like appearance, you know, kind of like a raised appearance. It's very distinctive. And anyway, that was the beginning of our tour. And then we walked over to the intellectual property department. Well, actually, some of the people were with us. And they said, this is what we do. Well, we take this program that the industrial designer comes up with, the file, and we put it on our machine, and we run it through another program which simply leaves the shape. And so, in effect, it gives us the picture that we will put into our design patent application. That is, the designer, in effect, the work product of the designer goes electronically right to the intellectual property department and is developed there for the purposes of putting together a design patent application. So we might as well show you what a design patent application looks like. I mean, you know, I'm talking about doing all this, so and I just happen to have a design patent application picture here. You know, this is no accident that Disney is so involved in all this stuff. This is the first page of a design patent application. It just shows the appearance of the product. Design patents are just to show the ornamental appearance of the product. That's all they protect. And there's a little rule of thumb that I tell people. It's so complicated. No, it isn't. It's not complicated. What you see is what you get. What you see is what you get. That probably sounds familiar to you, too, in your copyright area. I'm trying to stay loose about this. I mean, I'm not trying to separate a lot of this, but in effect, this is an example of a phone with a shading, showing the different surface areas. But this is a product. Now, we could have, in fact, you know, we could have an awfully interesting discussion about this from a copyright point of view, but I'm not going to. At this point. So, this is a phone. And this is a design patent. And then essentially that drawing would be created from the engineering drawing at Motorola, for example, that would actually have been created by the industrial designer. And they would then put the proper shading and so forth, and it sometimes can be done by computer, sometimes can be done by manual, because the rules in the Patent and Trademark Office are very specific about showing completely all the surface configurations. So you have to know whether something is concave or whether it's convex, or just, you know, how it looks. What you see is what you get. And so you have to show what you want to protect. But on the other hand, you don't want to show too much. You want to show, for example, what you think is distinctive about your product. So there are techniques for perhaps reducing, and not showing the complete product, but just a portion of the product. So this is the beginning of the process of industrial design. And of course, when the designer and then the patent attorney comes involved and gets the design patent application filed, and after a period of time, the patent issues, and I mean after a period of time. You talk about time and delay, you haven't seen anything yet. That's probably a favorite subject around some places. But you're looking at the average about 2 years to get this. And there are no rights, no protection for 2 years. Now, how would you feel about that? You're developing a product, you're putting a product on the market, and you have no protection for 2 years. Now, some of the products that I've seen don't last 2 years. I mean, how many, they tell me at Motorola that the phones every 6 months, they're changing the phones in some way. Now, they may not change the appearance of it, and that would be something to consider, but we're dealing with in a modern age. That's why they've gone to computers, to be able to develop the designs so quickly. There was a story they told me, and I don't think I'm speaking out of turn, that a client from Brazil came up, went into the design department, told them what they wanted, they developed the design, and in 8 days, they had a model of the actual appearance of that phone on the plane in Brazil. Because they have new technology now which allows you to actually create the shape and everything by computer of what you have drawn on the computer. So the general appearance of the phone can be presented and can be produced. And they say they have a policy down at Motorola, the management gave, that you'd love this one. Everything will be done in 1/10 the time. How would you like to work for them? Well, that can't be exactly, but essentially they are working certainly in that direction. So perhaps that gives you some idea of what an industrial designer does, and I don't think it has to be a cellular phone. It could be, certainly it'll be different in terms of the pace and the type of customers, but it's the same thing, whether it's furniture, whether it's clothing. I mean, look at the clothing industry and the rapidity of which that industry has to go through its design cycle every year. And then look at other products that have very long-term design appearance that don't change particularly. So I think, I brought this product along, not that it's particularly a good example in connection with cellular phones, but this happens to be a mixer, a Braun mixer, hoping to get a U.S. product. But, I think it's actually make it in the United States, but Braun's a German company. And when you look at it, you say, well, what could be a design, that might be protected by design patent? So this was actually litigated in the Federal Circuit, and the design patent was upheld in general for the shape of this particular body, and not for the configuration that relates to the operation of it, but you see they're actually together. They're intertwined. So we clearly have a problem in design patents in determining what can be protected, what is ornamental, and so on. We'll put that aside for a minute. Now let's talk a little bit about the history of designs around the world. I guess I have to tell you from my own personal experience, I just keep learning. I'm not sure I have a complete picture. But in Lyon, France, in the early 1800s, the textile designers were putting their designs, their lace designs, and patterns and so forth, in an envelope and filing them with the office in Lyon, where textile was big in Lyon, textile center in France. And those designs were kept secret, but protected under a system of registration. So we had secret protection of designs, and only if someone actually infringed that design would that design be pulled out of the envelope and shown, and then there would be some legal procedure that would occur where that person who came up with the same design would have to stop. And there's a question there. Was that copying? I mean, were we looking for copying? I mean, if someone had copied someone else's design, are we really looking for just the same design, irrespective of whether it might have been independently created? Good question. Seems like it was pretty much a copying thing, but they didn't really worry about whether there was proof of access. And if it looked the same, it's over. I mean, because designs like that were so intricate, to be the same is almost evidence of copy. Well, it was not long, 1 year later in the UK, when they developed their system, they set up an office for registration of designs. And we're fortunate to have the transcript after 1 year of operation about the pros and cons of how that office was working. I found it in a legal book somewhere in Germany. And it was doing all right except for one problem. It was an open office, so you could register your design and you would get protection for a certain number of years for that design. And it was publicly available. Anyone could look at the design. Well, now what would you do if you were going to compete with somebody? What would be the best source of information about a design? Well, you'd go to the office, look at the design. So they decided to close their office. So all of a sudden, the UHE system became very similar to the French system in that they were sealing off their design. So you see, there is a problem in this area, just how quickly someone can find out what you're doing and whether the design is available. And there's some questions of secrecy, especially in the fashion industry for some short period of time. And, so this is intermixed. But you can see we now have, like in the United States, as soon as the patent issues, the design becomes public. But while the patent is not issued, it is not public. So that is part of the history. And then we have to stay in France, because France is a fascinating country in many ways. It does things differently, you probably noticed. So they developed their own copyright law, and you may know perhaps that they are very art-oriented. They really believe that life and art are together. You drink it, you eat it. So you just, we'll protect the artist to the extent, and whether it's commercial art or whether it's industrial design or whether it's, paintings or whatever, it's going to be protected. So the French have a concept there under their copyright law that they will protect industrial design of products, shapes, by copyright. They have the most far-reaching copyright protection of that type in the world. And they also are a big influence on other countries that perhaps, are trying to debate what should we do with our copyright, how far should our copyright go. This whole question then is not very simple because we have different countries that seem to have different cultural emphasis and needs. And so, we came out of this mix kind of late, and where our copyright law came from, the UK, primarily organized around the classic forms of art and books and so forth. So it's not unusual to suspect that our system perhaps would be more like the UK, where they would develop a separate protection system for industrial designs for products, more or less, and then keep the copyright. That would be the tendency, But I must tell you that tendency is kind of changing. That whole area of development of the way copyright is looked at, and we may not call it copyright. We call it something else for reasons that I'll mention later. So our design patent system was the first recognized form of industrial design protection, and it was established in 1842, and it was primarily derived from the British system, which, as I indicated, was started pretty much at the time of the French. So I will leave for the moment aside the question of just, the scope of copyright protection and just the intricacies of what can be protected by industrial design. I can just add a footnote. I have a hobby of making a list of everything that's protected that's industrial design under the copyright law. And I must say I have a very long list. Toys, many things, architecture. And so people kind of think, you know, historically that it doesn't go in that direction, but actually it is, and it does go there. And so just a few words about, you know, you may have heard about the Berne Convention, you know, that this thing that came around here recently just kind of jumped on us and said, you know, here we are, you know, we're going to join the Berne Convention. Seemed like a good idea. Because we had another convention that we were a member of, but the Berne was the one that everybody else belonged to. So on industrial designs, the Berne doesn't say very much. In fact, it says we don't agree. But it has built into it something that I must say, for the purpose of the register and others, I've constantly mentioned this, that to the extent that we're willing to give protection for industrial design, for product shape, under our system in the United States, we will get reciprocal protection in other countries. To the extent that we don't give protection here, we will be denied, our citizens will be denied protection under the copyright law. So in France, we are denied protection, which would be given for things that we will not protect here, but we are given protection if we have essentially the same protection. There's this tremendous pressure under Berne to suggest that, you know, the more we can provide copyright protection for industrial designs, the better our design owners would be served. That, you know, that has to be within the law. So for the moment, then I'll put copyrights aside and turn to trademarks. You've heard of trademarks, I'm sure. Is that a trademark? Is Mickey Mouse a trademark? I was thinking about buying one of these hats and taking it to school and putting it on the first night I came back from Disney World. I think it would probably do something for my image. But they were about $10, and I couldn't quite. But anyway, you know, that's a trademark. I mean, when you see that, those ears, and whether it's on the Disney Channel, on the little corner of the screen, you know what channel, you know what source, you know the provider. That's a trademark. And you live and breathe trademarks. Nobody has to tell you about trademarks. You use them every day. You're the target, right? You're trying to be, we're educated. So trademarks do protect product appearance. Trademarks do protect product shape. So you might say, well, what's going on here? Is this a crazy house? I've just told you that design patents, I've just told you about copyrights to some extent, and now I tell you about trademarks, that they protect designs. Well, it's welcome to the world, the crazy world of design protection. Yes, we do get design protection this way. And I think you can think of a few shapes. Can you think of a few shapes that are trademarks? Say again?
Coca-Cola.
That's the first one I would think of around the world. That bottle, which was kind of phased out here, you know, it's coming back. But if you go into another country, I challenge you to find a bottle, a Coke bottle that isn't that shape. It is probably the most worldwide known shape. Now that container performs a function, doesn't it? But the function of the shape does not necessarily, you know, affect the function it performs. It does certainly the size, but that's incidental. So trademarks, there are other trademarks I think that you can identify that have the Mickey Mouse hat, this three-dimensional hat is a product design. And architecture, with that Magic Kingdom castle, shape of the building and all that is protected as an image, is identified with that particular company and a source, and that's what trademark takes to have protection. So I guess you learned, maybe by accident, I have taught you something. By accident, I had told you, I mean, I didn't plan to, but you know, that there are different forms of design protection and different forms of intellectual property, and that they overlap. And they give you different degrees of protection, and they're different around the world, and every country has its own view. So welcome to the crazy world of design protection. But it's not so crazy, because didn't we start off that this is important? We all said it was important, right? It's all important to the product and to what we buy and why we buy it. So we better, we better use this, whatever we've got to protect this. So let's go talk a little bit about the history of efforts in the United States to protect designs. And perhaps the one theme that I have to leave you with is one of the trends that is occurring in design protection is simplicity, to make things less complicated. And we are not the leaders in this, frankly. The rest of the world, if you step out of this room and you step out of this country like I'm going to do on Friday, I'm in a completely different world, a different culture and different needs and different laws. But in those other countries, things are changing. And they're changing essentially to make design protection more simple, more effective. And I'll give you some examples of that. But let's talk about our country and what we've tried to do. It probably might not surprise you to think that there was a tremendous effort in the 1800s, the mid-1800s, when we were all using stoves. Wood stoves, coal stoves. You probably don't remember that. We had these electric stoves, but it wasn't long ago. 100 years ago, people were living in buildings, and they were heated by coal, and stoves, and many people out in the country, even now, still use this. And they took on the appearance of some really nice furniture. They were in the home. They did a little design work, had some features around it, and so forth. There was a tremendous effort in the mid-1800s to protect the shape and the appearance of those wood stoves, and they tried to develop a new form of legislation that was quite simple. So simple, if you copy it, it's illegal. If you copy it, it's illegal. Now that sounds like copyright, but it wasn't copyright. It was a separate bill, separate legislation. So after that effort, which failed because they wanted to protect the parts of the stove, the griddles, all the different pots and things that were associated with it, a lot of controversy developed. As you might imagine, certain companies were dominant. This happens, especially in things you do in the music industry. The publishers become dominant, the record companies become dominant, and that, right or wrong, that affects what Congress does. Right? They just don't want the big to get bigger. There is a tremendous political environment involved, as you well know, probably in the copyright area. So it too was it with design. So that legislation never got passed, although it was constantly considered. In the early 1900s, a similar effort was made to try to get a simple form of protection. If you copy it, you're guilty. It's that simple. There was, in this particular legislation, an effort to set up some kind of a registration system, a very simple registration system, something very similar to what you do with copyrights, deposit. And these bills went through several variations. There was a constant interest in this to make a simplified form of protection. And the situation reached a peak in the early 1900s, and this is where it's like playing baseball. You certainly remember everything that went on when you were playing baseball, and it's part of your life. You can't take it out of your system. The history, the people, the scores, everything. So I was playing baseball. I was playing industrial design at this time. So I knew the players. I knew what was going on, and so it's part of my life. And what I found out was this legislation, which had really broad support, over 80 sponsors in the Congress, in the House, and a tremendous support generally, seemed to boil down to opposition between two situations. The car companies had parts for their cars. They wanted to control their parts and protect them by design, by this legislation. And the people who made the parts for replacement, not the companies that made the cars, but the ones that were making the replacement parts, didn't want the car companies to get the protection for their parts. And so we had a really fierce battle between the original your bill for the insurance. So we have big money here. We're talking big bucks opposing each other, in Congress. Well, you know what happens in Congress. Big bucks opposes big bucks. Well, Congress doesn't seem to know what to do. They just they want consensus, cooperation, and if they can't find a solution, so they worked on this for a number of years. About 1993, they came to the conclusion that the two sides wouldn't agree. I know they spent millions of dollars lobbying, and the end result was it didn't happen. And so that legislation sat there. But there was a tremendous history. And out of that, one particular form of legislation did pass to a particular industry, the semiconductor chip industry. They came to Congress on their own and said, we need protection. We need to stop people from copying our mask works. We need to essentially, we're the number one. We want to protect this, the appearance of these products, the shape, not the shape so much, but the appearance of the chip layers. And they got their legislation in 2 years. They made their case, and let me tell you a little secret. And it's a joke. I mean this sincerely. It's one of the few jokes that I come up with. They took a chip out of the industrial design bill that was pending, that never went anywhere. They shrunk it down to just cover chips and added a few other things, and that's how the law became, the chip law became the law. That's the gospel truth. It may take you, months to figure out what I just said to prove it, but I know it because I lived through it. And so therefore, it might not surprise you that you actually administer this law. And I know you're considering, just how to make it more effective in the area of that technology. But it would not then surprise you that if a group of people from Congressman Cobol's district that make boats, people who are being put out of business because of the copying of the design of these boats by others, because it's so simple, would come to Congressman Cobol, who happens to be the chair of the Intellectual Property Committee in the House, #1 man, and says, we need some protection. So Congressman Cobol looks around and says, well, didn't we have a design bill pending? Maybe we could use that. So they just grabbed it, literally, as it came, and I have personal knowledge of this, said it's a good structure. Let's make it specific to boat hulls and do a little adjustment here, but the basic structure is going to be the same. If you copy, you're going to be liable. Now, not quite that simple. So now you have the boat hull legislation, and you have it to administer, and I'm sure you don't quite know what to do with it, because it's at least technically here only for 2 years, unless it proves itself, I guess, or unless Congress can, develop the sufficient support. But I guarantee you that there is sufficient support. If Congressman Cobol says you don't get the design Millennium Copyright, the Digital Millennium Copyright Act until I get my boat hull thing, it might suggest to you that there is some support there. And I think, for other reasons, there's probably support built in for that. So, in summary then, the legislative history of design protection in the United States has been a little bit spotty. We've tried to do general protection, but we've come up with 2 specific protection areas, both of which you're intimately familiar with and involved. So let me tell you essentially how this works, so you would get some idea, because it's important for the future in discussing the trends around the world. Sometimes we just sit here and look at our own selves, and if we don't look outside, don't look out what's going on outside, you might not have the same perspective. What this legislation that was pending and did, and what the CHIP Act and the boat hull legislation did, was simply said, if you go out in the market, if I have a product and I put it on the market, I'm protected. Does that sound familiar? That's what happens with copyright. That's the best you can do. You've got the best system in the world to work with. And then, within a certain period of time, you register. Sound familiar? Now, this is required, or you lose protection, which is some difference. So then you get, in the case of the chip law, it's 2 years. You have 2 years to register. Then, if you register, you have a continuing 8 more years. And all the office does is look for the formalities and to be sure that it's generally within the subject matter that was intended, and out it comes. It's registered. Whatever your time frame is, in a few months, it's registered. And that's exactly what design owners want. That's what they need. You wonder why people are banging on your door? Because you have the best system. You have a system that people want. As evidenced by the fact that here you've got 2 industries, the chip industry and now the boat hull industry, and the boat legislation. This could be an exam, but there's no exam tonight, no exam at all. But 3 guesses, and the first 2 don't count as to what the boat hull legislation does. It gives you 2 years of protection from the time the product's introduced, and then you register it, and then it's registered, and then you get 8 more years. Does that sound familiar? Yes, it does, because it's the same, more or less, as the chip law. So, and the standards are built into this legislation. It is very severely designed to protect the public against any kind of false use or misabuse or of any kind of the system. I mean, we really design, and I have to say some of this I put in, we design things that this system would not be taken advantage of. For example, the boat hull legislation requires that you can't get protection unless you actually have a boat or an embodiment of it. Now, that's not true of copyrights, and that's not true of design patents. You can get a design patent on an idea of what a design should be. So this means that your protection under the boat hull type legislation, which is unique, actually, is developed on the basis that there has to be an actual product, or at least something that is in a product stage. So there are a lot of interesting and good features in that legislation. Well, enough about the United States. I'm going to go to Jakarta on Friday, and I can't tell you much about Indonesian design law today. They're in a state of flux. No doubt we'll talk about it down there. But really what we're talking about at this conference is the developments in intellectual property in the internet, which is another fascinating subject. But the lady who's running this conference, who I've worked with for the last 2 years at the University of Indonesia, her special interest is, guess what? Design. And so she is working on the future development. But remember, a developing country may not need the same system, so there's an interesting question of what developing countries should have as far as design protection. But I can tell you this, they're leaning towards something like copyright. They see it as a very effective and quick system, and they just don't have the office staff and to really have a complex system. So this leaves me in the few minutes that I have left, because I want you to have opportunity for questions. So if you have any questions, if anything comes to mind, please. I love to talk, but I'd rather talk about what you're interested in. But maybe we should just briefly talk about what's going on around the world in designs and why some of these things are happening. And perhaps what I've noticed around the world is a trend to simplification. I said that at the beginning. To simple systems and to prompt protection. Prompt protection, right away. Which kind of leaves the design patent in trouble, doesn't it? Because what is it, 2 years? And they know it. They're working now, they've got their system down to reduce pendency. They're working hard on that. And but they'll never get it down below a year. There's some ideas about that, but we can't talk about it. It's possible they could do something, but frankly, the system that is kind of based on what the Boat Hull Act looks like is very attractive. So what's the rest of the world doing? I think the first place you look around the world now is the European Union. They're forming 15 countries, We've got Scandinavia involved now. They're working into Eastern Europe economically. There's a tremendous surge of new law and new systems. And so they have a new design protection system just about ready to be installed. Guess what? Guess how it's designed. I wouldn't want to say gospel that this happened because I don't have a direct evidence. But they seem to like what we were talking about in the early 1900s and in 1990. They thought we were going to pass it. So their community design system, which will be effective throughout all these countries, will have protection immediately. The registration after 3 years, if you want it, to continue the protection to 25 years. There will be a more strict standard for novelty in terms of whether you are new, and there's that element that's perhaps different. But the basic structure of this system is the same, pretty much, as to what the protocol legislation is. And also the CHIP law, at least, but primarily the voting. That seems to be what a lot of countries are going to. Quick filing, immediate, if they don't give protection before registration, they give it quick registration, very quick. And one of the reasons that's going to happen, happen more effectively, is because of the treaty that Maryland worked on for, what, 5 years at least? At least. We had a lot of fun doing this. And there were some problems, right? There were some disagreements.
Well, certainly there were problems.
And I won't say where they came from, but EU has the familiar ring in it. But we solved these problems. So there is going to be a treaty. The meeting's going to be this summer. And if we're lucky, the U.S. will be able to agree to this treaty. Now, what is this treaty going to do? It's primarily linked to the design patent. But what it would do is set up a central system for filing these applications and then have them essentially automatically be established in the various countries. You do all your work in English. It's a nightmare now. When you do your foreign protection, you have to deal with every country, its own language, its forms, its currency. So WIPO, which you probably have heard of in Geneva, has been working very hard to centralize their processing. And so they have established a central treaty for trademarks called the Madrid Protocol. They've established a central system for filing for patents called the Patent Cooperation Treaty. And they are hopefully, they will have this new revised treaty for design. So, that's probably the next most important thing to just improving design protection in this country, is providing a mechanism for linking and establishing protection in other countries. Now, it's not telling you which exact system, to use. It's not a harmonization. It's more of a procedure. But it's some harmonization in it. So I must say, though, that the conversations that I hear around the world are essentially in the direction of what the European Union is proposing. And actually not just proposing, but doing. So with that in mind, I have to say, that the boat hall is not just a sleepy little thing that kind of wilded its way through Congress. Actually, what happened was, it is, know it or not, and whether Congress knows this or not, I don't know, but it's really part of a grand, to use a pun, design that's occurring around the world, which is trying to simplify design protection. So, I guess in summary, as far as what I tried to mention today, since I said there'd be no exam, and I said I wouldn't talk about law at all, is I said that I think I've tried to show you that designs are important to you and to businesses. And probably we need a system in some way to prevent imitation, because that lawyers, is going to be advising the copiers. And that our current law in the U.S. has a lot of options, and probably is not ideal, generally. But we rely primarily on the design patent, but also on trademarks, certain situations. And also, frankly, in my humble opinion, where we can get it, the best protection is copyright, because it has all the advantages that we have been trying to establish. Quick protection with a very simple procedure. When you get into patent law, I mean, you are really getting submerged in an awful lot of complexity. I mean, frankly, it's a shame to expect people to know patent law to do design work. And I know that. I'm a patent attorney. I sympathize. And I guess the final point is that the improvements that are occurring around the world towards simplicity and to quick filing and quick protection, I should say, with or without filing, is something that I think is eventually going to show up at our doorstep, either through some kind of a treaty discussion in GATT, or just the pressures of the different governments getting together and saying, quite frankly, to the United States, you just don't have a very good design protection system that, you know, we think you should. You want something from us, we're going to expect you to do so. So that pressure exists now as partially the reason why we're getting all these improvements in that area. So and you all are a part of this. I mean, you probably don't see it in that context, but it is. You're just part of it now, and then it's kind of a strange situation where the way they've given it to you. You know, it's kind of unfortunate, but if you see it in the broader perspective, it might be a more acceptable. So, well, I haven't shown you all your visual aids that you can look at those, and each of the visual aids, I made a little explanation in the beginning that you could see what that is, but I promised you that I wouldn't get into complexity, and I hope I've kept my promise. But I think, are there any questions? We have probably about 1 or 2 minutes.
A quick one. Would you say then that if the underlying thesis or purpose of most intellectual property law is the betterment of society to get these inventions and creations out for the public good, the thing that must be missing here is the patent system. You've got no protection until you've really got it out there. It's long, complicated, cumbersome. It's copyright, but it doesn't protect the shape of that mixer. And if that's a valuable commodity, it's that piece of it that seems to be missing in
Well,
our
the design patent law would, but the utility patent law would not protect. That's why we have a problem in all this vocabulary. You know, patents. There are 3 types of patents. Yeah, you didn't. You know, you really. I suppose you really did ask me to. We could have spent the whole time talking about the social economic value of intellectual property and the right for people to copy, and the fact that we shouldn't set up barriers. You know, where does intellectual property? You know, where is the legitimate area of intellectual property exist? Why should we why shouldn't we just let people copy each other? And the standards that have been plugged in to make that argument that for intellectual property is that for patents it's novel and it's original, that you have not copied it for somebody else, you've done it on your own, and you've done something novel. In fact, patents are even higher than that. It has to be above the skill of the art, or it has to be what we call non-obvious. And that's a standard, meaning that, you know, just ordinary stuff can't be patented. So we should, as long as we play that rule, play that game, every patent should bring us something new, right? Something that contributes to society. As long as we follow the rules.
I will say this comment, and I wish we had brought it here. There are a lot, we've gotten sort of into the feeling that maybe designs are not worthy of protection. And yet, as you know, there are many things that in the visual arts thing that you look at every day that probably are much more original and novel than things that we grant copyright protection to, but simply because they're utilitarian and they're designs and there's no separation, you reject them. And for that reason, I think more than any, we really need design protection in the United States, a good design system.
Well, yeah, and you know, the patent, we put that aside. What about trademarks? Well, you know, how far should you go with trademarks? You know, well, the reason we have trademarks is to prevent people from getting confused. You know, if I have a trademark, if you have a trademark, and it's the same one, how do I know, you know, who's the one I'm relying on? If my name's Fryer, I'm a William, and if somebody comes along and uses my name, I mean, I could be insulted and also could have some bank fraud. So we got to separate these things. So we call unfair competition or trademarks, you know, kind of the way to keep people honest, so they don't confuse with each other. So trademark law, you know, has the potential for giving a lot of design protection, but in fact, it probably is pretty limited, if, you know, when properly interpreted. It's pretty limited. You know, copyright has the separability problem, and you know, built into the law.
Would you take a minute to comment on your view of the look and feel court decision and whether that was appropriate in terms of copyright law, or if that is not trying to take copyright into design protection?
What are you thinking about? What, do you have a decision or a case?
There is a decision, and don't ask me to quote it because I didn't look it up before I came. There is one court decision which determined that infringement could be granted because of the copy having the look and feel of the original.
Yeah, well,
I'll look it up.
sounds like
somebody in here ought to remember it.
Willen case in computer software. You know, the look and feel is a.
No, not Lowe's.
I'll tell you,
Software.
I don't use that term. I use substantially identical. And then when you get into software, you've got your own problem there. But I think, frankly, that the standard for infringement, when you're dealing with copying, has to be it's a very close comparison, right? You know, this is not the same. This is the same. I mean, it's very strict, very narrow. So I think in order to put this in a context of the economic system that we live in, where we believe in competition and intellectual property should, you know, be strictly enforced, have very fairly clear lines so that people know when they can, you know, use what they have to use. The problem with designs is the fact that the design overlaps with the functional feature, then it becomes a little more complicated as to what you're protecting sometimes. Now, copyrights has taken the comfortable way out by separability. But the other laws, trademarks and patents don't. And they leave some general principles there, but they're harder to interpret. Yeah. And for the boat hall, you know, you've got the same problem. You've got certain limitations that you can't protect certain subject matter so that people are free to use that subject matter. And it's only that subject matter which is not excluded, which is actually going to have an impact. Yes.
I have a question about the boat hull. What kind of craft are we talking about? And does that then control the kind of rocker, how wide the gunnels are, for example, how much rocker are on these crafts?
Well, that's a good question. I mean, it's clear that it's the hull and the deck. And it's pretty clear that it's nothing else.
What kind of craft is it? Is it
The size, there's a
kayak,
limit on size. I can't remember, is it 250 feet, 200 feet? So, they talk about, you know, just the shape of it, you know, pretty much. That's what they're looking at. I'd be very interested to get into a more intense discussion on this because I'm still thinking about this. You know, while I might have been involved in this at some point, when it came out, do you know how fast this, I told you that the legislation for the CHIP Act came out in 2 years, which I thought was astounding. Well, let's see, the bill was filed on October 22nd, 1997. I testified on October 23rd, 1997. It went to markup at the end of the month, at the end of the year. It became passed by the House at the beginning of 1998. It went to the Senate, and it came out and became law on October 28th, 1998. The way I figured it, that's a little bit, just slightly more than 1 year. And if that's not a record for something like this. Now, that doesn't mean, I mean, that sounds like maybe a lousy way to run a sausage factory, but the fact is, the legislative history over more than 10 years had established the basic structure of the design system. We'd had the CHIP Act functioning for a period of time, so in effect we were merely adding another form of protection. So there are a lot of questions that, like you asked, what's protected, or what should be. For example, I I was down in New Orleans, what professors do on their holidays at a law professors meeting. I went to a boat yard, and I talked to the people that manufacture fiberglass boats, took pictures, and discussed a lot of the technology and everything. And so now I have some ideas that I didn't even know about when I testified. But it's still true that they're very easy to copy. You give me a boat, I can buy a boat, and I can make a mold and then duplicate that boat for almost nothing. Whereas it might have cost $100,000 to $1 million to build the actual original boat shape. There's a lot of economics there. If I answered, in general, I mean, you see, that's about the limit of it. It's not going to go to the masts or the rigging or the mechanical features or even the cabin, although I think we might want to be a little bit liberal there, perhaps. But they do make their cabins separately, mold them. They make their decks, they separately mold them. You tell me when you want to pull the switch here.
In the proposals that have been made for design bills, are they talking about the originality standard equivalent to copyright law, or something closer to the novelty standard of patent law, something in between, or is it basically just similar to copyright only with certain other features?
No, it's more similar to the CHIP Act. The answer to your question is quite easy to make, I think, in this case. It's not always easy, but the word originality appears in the legislation, and it actually defines it. And it essentially says that it has to be something more than trivial. You're familiar with that, and you have to interpret that. But what actually happened, they also put another provision that specifically says that you can't protect commonplace features, ordinary features, things that had essentially been, and again, you're comfortable with that too, I think, in a copyright sense, especially in the visual arts area with rings, things of that nature. Kind of debatable, but so they have built in specific language that suggests a minimum level of novelty. That if you can find that type of feature in this design and nothing more, but it also, there's a provision in there, if you find that these common shapes and so forth have been used in such a way to really create something that's different in appearance than the common. And I think for those of you working in visual arts, I think I can probably communicate to you on this, because you have to go through this mental process every time. And the end result is that they tried their best to establish a floor so that what's commonplace and generally used in the industry will not be protected. And what is actually distinctive and different enough to be novel in appearance, without any judgmental question of what is good or bad. And you're comfortable with that, probably. That would be protectable. So in effect, they have built a very low level of originality, but they have based it on novelty. And in the sense that I think you probably, at least in the visual arts area, tend to use something very similar to that in the approach. Yeah. Now, when it comes to boat shapes, in class Monday night, I thought about inviting somebody down from here, but it was my kind of first effort to go through the bill with the students. And I took a lot of boats out of a boat magazine, and we looked at them to see which ones, differ and everything. Tried to figure out, what would be protected. And, so a lot of things are not going to be protected. And you don't have to worry about that to some extent, because the law will take care of itself. People cannot get infringement, you see, based on the features which are excluded, right? I mean, that's not your problem. You're not here to essentially prevent things from getting out that might be, perhaps have some unprotectable subject matter. As long as it has some protectable subject matter in it, you're okay. Isn't that, I think that's kind of the rule without thing that you use. Is there any more questions? Yes?
I was wondering whether you have a feel for, first of all, do you see a broader design law coming anytime soon, or is it more likely to continue to be piecemeal with this industry and that industry coming forward to do protect their material? And if it's the latter, do you have an idea of what particular design industries are warming up?
I can tell you who the hot people were in the 90s. Luggage, furniture. Although furniture is quite divided. There are a lot of copiers in furniture. Dress design and fashion in this country in the early 50s decided to opt out of this legislation, but they're coming back. They're thinking about this, and they really are considering it. The problem is, I mean, overseas, the dominant force for design protection is textile and fashion out of France and other countries. No surprise? So you find, if I go to a meeting on this treaty, I mean, I don't have to tell you this. Marilyn can tell you this. In the back row, there were probably about 30 people from different industry groups. 5 or 6 of them, the largest block, were from the textile people from various countries, organized to get improved and quicker, underline quicker. So when you read the GATT treaty, and you read Article 26 on designs, you'll see there's a paragraph in there. And it says that each country will do its best to simplify, reduce the cost of protection of textiles. Now you may think textile means pattern, like you have here. They think of it in the fashion sense as well as the pattern sense. Now that's the pressure, and if that could get into GATT, it has reached the highest level of political power. And if that is a pressure. So I would say that probably is not a problem in the United States. I think the fashion industry would probably, pretty much welcome whatever some things that you can give it. Maybe a little bit of extension to certain aspects of fashion. You already, in copyrights, you've given them some protection, masks, and some costumes and things. That was appreciated. I think it solved some of the problems. As far as the luggage industry, I think is big. Of course, the automotive industry would love to have protection on their car parts. Come hell freeze over, that is not going to happen. They were not only the source of the problem why this legislation did not get through, they wouldn't compromise, and we had compromises. Just to make the long story even longer, when this legislation went into Europe, and the community design, the European community design, it took 6 years to get that legislation essentially approved. You know who was the opposition? The same people in the United States who didn't want protection on parts. They went over to Europe and started lobbying. For the first time in the history of the European Parliament, people wanted to take them out to dinner. They wanted to have programs that were disguised programs and conferences that people were invited to influence their outcome, which is what we do all the time here. But in Europe, it was, nobody ever saw this kind of a grand slam type of lobbying effort. But this is absolutely the gospel truth about all this. They unfortunately, the opposers ran up against a brick wall because the European Union decided they needed design protection. They couldn't refuse it. It had to be done. There had to be a design system for Europe. So there had to be a compromise. So there was a compromise. In fact, it was hardly a compromise. They just decided to disagree for a while. That's the compromise. And they let the protection system go forward as originally planned, with the protection for the car parts. Because overseas, industries, the car industries are really powerful, especially in Europe. The parts manufacturers are weak, and this is true in Japan too. So the kind of problem we're having here, where what you might call the generic copiers, like in medicine, you get the generic drugs. Those people that have so much power in the United States, in Congress, don't seem to have the swing of power in other countries. Now, I personally think that, we're not going to change just because somebody else changes. So we're going to make adjustments, but we're not going to just completely adopt the international approach here. Yes?
When you talk about car parts, are you talking about parts that have some artistic element to them, or even engine parts and air filters.
Well, sure. I mean, don't you just look at your bumper? I mean, what a beautiful bumper.
Well, I
And
mean,
what
that
about
has-
the fenders? Don't you just see the shape of the fenders?
Well, I mean, that has a
Good.
visual element to it.
I'm making fun, I'm sorry. This is what they're protecting. And there's very little art in it unless you happen to have, you know, one of these cars
Custom
that have
chrome.
been modernized, what do you call them? Where you do your own design work. But coming off the assembly line, these have very little design distinctiveness. But they are protectable in the sense of the design law, as long as they meet the novelty requirements. So what happens is that Geico, they're the principal supporter against the legislation, decided, you know, that they were going to have to pay a lot of money for these parts if they came from the original manufacturer, because there are lots of bumpers and hoods that are being dented every day. So they decided that design protection was a bad idea, because it would give the original equipment company the control of those parts. And then the companies that make the parts that are competitive, that look alike with the original, they got together with the insurance companies that have to pay the bill. Have you noticed that when you, I don't hope I'm not telling the story out of turn, but if you go to Geico, they literally tell your repair shop what part to use, and it has to be a duplicate and not necessarily original, and then you have to negotiate with them on that. Have you had that experience?
Have you seen consumer reports this
Yeah.
month?
Well, see, this is all part of a grand plan that the insurance companies have to keep the costs down, and it happens to interface with intellectual property. And it happens to interface with design protection, just because that happens to be the primary way that form of protection, you know, that particular feature. So it's amazing what happens, you know, when you think you're doing something for the good of the designers and the good of the company, you find you're in a very complex economic. I mean, she's talking about the role of the economics of intellectual property. You get to a situation sometimes where intellectual property just isn't necessarily good for everybody. I mean, it hurts some and helps some, so you have to make a compromise. So what you usually do is shorten the term of protection, right? Or work out some kind of compulsory license in copyrights. But generally speaking, in areas of patents and designs, compulsory licenses are not encouraged. The owners want to have the rights, whereas in copyrights, you're used to having compromise and making compromise. This is something quite different between these two areas. You have always had large interest groups, dominant forces, and without a compromise like a compulsory licensing, you know, like the jukebox license, or you would never have ever had a copyright law. These people have to be put in their place. They have to be kind of kept the power that they control. Now, the patents and trademarks have not quite gotten to that level of difficulty, so the compulsory license has not been a major player, but it has in other countries. We live in an unusual world here of competition and freedom. In other countries, they have laws that say people who own patents and don't use the patent for 3 years can be forced to license. It's all part of a grand plan in some developing countries to see that patents don't take over their economy. You know, the foreigners don't take over their economy. But that's another subject, I suppose, not totally different. But anyway, you've been very responsive, and it's been fun to be here. And I wish I had classes like this at the law school as asking such good questions. Thank you very much.